A number of states, including Virginia, are now entering phase 3 of reopening in light of the COVID-19 virus. What does that mean? That means many employers are now opening up and employees are coming back to work. One of the questions we often get is, how long can I stay at home? What are my rights to stay at home and stay safe? So let's talk about that. The EEOC, or the Equal Employment Opportunity Commission, the big federal agency that covers many employment laws, issued guidance saying that simply being afraid of coming back to work is not grounds to stay home. It's also not grounds to stay home if you are in a high-risk category. For instance, if you are an older worker, let's say 60 or older, if you're pregnant, those also are not grounds for you to stay home. However, there are some laws that can provide you with protection that allow you to stay home. One of the first ones that is specifically tailored for the COVID-19 virus is Emergency FMLA, or EFMLA. And it broadens the Family Medical Leave Act, which traditionally only applies to employers with 50 or more employees and to employees that have a serious medical condition. Under the Emergency FMLA, it applies to all employers, regardless of size, and you can stay home with a certain amount of pay if you have a child care related responsibility due to COVID. So your school's been shut down, you no longer have daycare, and so you have to stay home and watch your child. You are protected if that is for your reason for up to 12 weeks. Now, of course, if you've already been on that leave and that leave is exhausted, then that protection no longer applies. But if you still have child care responsibilities and you haven't requested that leave, you can still do so. Another law that applies is the Americans with Disabilities Act, which applies to any worker that works for an employee with 15 or more employees who suffers a disability that is covered by the Act. And this can be a temporary disability. But some of the disabilities that might apply to COVID would include asthma, cancer, other medical conditions that could be impacted if you come back and are exposed to the virus. If you have a medical condition of that type, then you can ask for what's called an accommodation. That is a change in your working environment to allow you to continue to work. One of those accommodations can be staying away from work and telecommuting. Note that that is not an automatic right under the law. You have to ask for it, and your employer has to engage in a good faith negotiation with you to try to find a way that you can continue to work and perform your job without putting you in danger because of your disability. So know that you can ask for it for your employer. Being able to telework is an accommodation, and that could be some protection. And then, of course, there is the regular FMLA leave. So if you have a serious medical condition, if you've been hospitalized, if you are under the continuous care of a doctor, which certainly applies if you have COVID, then you have a right of up to 12 weeks, it's usually unpaid, but 12 weeks of leave and job protection. If you're in the District of Columbia, you have up to 16 weeks of leave. But again, you have to have what's called a serious medical condition to be covered by that act. So those are the three laws that you should be looking toward: Emergency FMLA, the regular FMLA, and the Americans with Disabilities Act. Those are the three big ones that can give you some rights to stay home to protect your health.